I'm really excited to have Larry, and I hope I don't mess up your last name, Larry, but it's Larry Keuter.
Keuter.
Larry Keuter with us to talk with us tonight about conservation easements. And as I mentioned before, this isn't an evaluation of the current easement of the Park Hill Golf Course, but rather easement education. Larry has made it, definitely read over the Park Hill easement, so that way if there's terminology or specific questions where we need, understanding, those kinds of questions can be answered. But again, he's not going to be giving us a decision or something like that. So again, this per your request, this is some education. You've got his bio. Hopefully you've had a chance to review that and read it. And Larry, I just want to say thank you for answering the call and being with us tonight. I know that you just got back from being out of town, so being with us tonight, we really, really appreciate it. And so we're going to turn the floor over to Larry, and then after that, we'll have some time for some Q&A. And then we'll move into our next speaker. Larry, the floor is yours, sir.
Well, thank you, Dr. Ross. So what I was asked to do is just talk about conservation easements as a general topic to give you kind of some foundation and background for this kind of unusual real property interest, so that you can have some context as you look at the conservation easement that I know is a subject of a lot of discussion and analysis between the Clayton Trust and the City and County of Denver. And if there's specific provisions of it that you'd like to ask about, what's in it, what might not be in it, I'd be glad to do that. But I think my charge, and I take my charge today to be just a little broader than that. So what I was going to do is talk probably for about 15 to 20 minutes at most, and then leave a lot of time for questions, specific questions or more general ones. So kind of starting at the very beginning, conservation easements haven't been around in a formal sense for a very long time. They were created, authorized in Colorado by legislation in 1976. So the legislative authority to create this kind of property restriction that can be enforced by an entity rather than by a neighbor has only been around here in Colorado for about 45 years, and it was pretty obscure through the 1990s when it became more of a focus. But conservation easements, it basically are just enforceable restrictions on what can happen on property, and they're intended to be created to protect the conservation values of a property. They're granted under Colorado law. They have to be granted by the owner of the property, which is typically a private party. On occasion, it could be a governmental entity, but typically by a private party. But it has to be granted to either 501c3 conservation nonprofit, so a nonprofit organization recognized by the IRS. And I'm going to refer to that kind of entity is typically what we call a land trust. A land trust that you probably have all heard of is the Nature Conservancy. They're one kind of a land trust that work on an international level. But in Colorado, we have about 30 or 40 501c3 nonprofits that function as land trusts. Another example is Colorado Open Lands, which works on a statewide basis. There are local ones that work just on a countywide basis. So this conservation easement has to be granted to an entity like that, IRS nonprofit entity, or to a governmental entity. The City and County of Denver is a governmental entity, so it's proper that they're the holder of this Clayton Trust conservation easement. But because there are public and private benefits that flow from this, you can't grant a conservation easement to your neighbor. It has to be, to have the full authority of law in Colorado, it has to be granted to either that land trust, a conservation nonprofit, or to a governmental entity, and they have to be the holder of the conservation easement. So typically then what a conservation easement will do is it will identify the conservation values of the property that are to be protected. And those can vary. The common ones are wildlife habitat, protecting the habitat for elk calving grounds, for public recreation, where the property that the public can come on and do public recreation activities, or for open space purposes. And a conservation easement may have all of those or may just contain one of those benefits. So if you saw my bio, you see that I've done about 600 conservation easements on probably now well over 1 million acres of land. And it's the wildlife habitat and the open space benefits that typically are the purposes for conservation easements. But the public recreation does show up occasionally. And so hiking trails, biking trails, a golf course would qualify as public recreation. So the conservation easement promises, typically in perpetuity, promises to protect those conservation values. And the conservation easement will have remedies for the holder so that they can hold the private party to these promises. It will limit further improvements on the property to maybe no further improvements at all, but it may be that it allows some improvements that are generally consistent with those conservation values. So a conservation easement that crosses my desk pretty commonly would be protecting a couple thousand acres of Colorado ranch land, and it allows some agricultural buildings on one small portion of the property and allows some new improvements within that in some limited sense, but it protects the rest of the property from ever being developed, subdivided, or built on, so that the wildlife benefits, the agricultural use benefits, and the open space benefits that come from that protection are protected forever. I said that these conservation easements are typically perpetual. In theory, you could do a conservation easement for just a term of time, like 10 or 20 or 50 years, but that's really, really rare. So what we almost always see are conservation easements that are done forever. And I think one of the places that plays out in this discussion is that the arena of this kind of private land conservation is designed not as kind of something temporary, but as something permanent for a community. And the benefits that flow from it are tied to those kind of forever promises. So a conservation easement, if you ask, well, why would a rancher, a rancher can keep ranching if he doesn't put a conservation easement on. Why would a rancher ever do this? The reason is that it can be complicated. One of the reasons always is that they care deeply about their land and they want to see it not developed. But there are some economic benefits that flow from it as well. Since 2000, Colorado has had a Colorado income tax credit for the donation of a conservation easement. So without going into the detail of how that works from a value and mathematical standpoint, somebody that donates a conservation easement can get a Colorado tax credit for the value that they give up. And that can be a substantial economic benefit. There's also a federal charitable deduction, just like the donation you may make to your church or the Red Cross. The value of the conservation easement is a federal charitable tax deduction. And so a landowner who makes the donation of a conservation easement can get a federal charitable deduction for doing it. And that can also have some significant economic benefits. So that tempers the decision to give up the value of these development rights that every property has. But what we also see are the purchase of conservation easements by governmental entities at every level. In Colorado, we see it with Great Outdoors Colorado spends significant monies on what it deems to be special properties and will pay the landowner a value, some portion of the value of the conservation easement to restrict that property forever and protect what Great Outdoors Colorado deems to be the values of that property to our state. The Colorado Parks and Wildlife does the same thing. There are a number of Colorado counties that have conservation easement purchase programs, and that includes Arapahoe County, Douglas County, Routt County, and Steamboat Springs all have, and Jefferson County also, all have some public source of money where one of the things that they do with that is pay landowners to restrict the development of their property for the benefit of the entire community. An advantage to a landowner in doing that is they get, if they're not interested in developing the property and they think they're getting compensated appropriately, they will still get all the other uses of their land. If it's 40 acres in Douglas County with not much on it, they get to use it for recreation purposes. Maybe they'll have a house on it. They can't do more than that, but they get to use the property for the things that they still value. A rancher or a farmer will get to still conduct the agricultural activities, make a living, do all the other things, but they will give up and sell the development rights. So they get some of the benefits from the property that they perceive are of value to them while selling this restriction and giving away the development rights, which is something that they're not interested in to begin with. So we have programs at the state level, we have programs at the county level, and we have programs at the federal level that do the same thing through the US Department of Agriculture. So there is a lot of economic incentive for special properties to be protected with conservation easements. The most common conservation easements we see do tend to be a little bit in rural areas. You have more land, you have more habitat, you have larger parcels that have more open space benefit. The nonprofit that I do the most work for, the Colorado Cattlemen's Agricultural Land Trust, just by its name gives it away, it works in ranching communities primarily. But there are a significant number of conservation easements still used in urban areas. And a good example of that are a couple properties in Greenwood Village that back up to the Highline Canal and have parcels large enough that protecting the backside of those properties for the wildlife habitat and the open space for people using the Highline Canal is of benefit to everybody. So they come in all shapes and sizes. And in my history, the smallest one I've worked on is probably about 5 or 10 acres, and I've worked on some as large as 40 or 50,000 acres in size. So they come in all sizes and shapes. The conservation value of the property can come in all sizes and shapes as well. I am at a disadvantage, maybe good or bad, about what the motivation was for the Clayton Trust conservation easement to the city and county of Denver, that whether it was, there was some it has the usual lawyer language for good and valuable consideration, which tells you nothing at all. And I use that all the time as well. So that's not hiding anything, but I don't know what the circumstances were of that conservation easement being granted to the city and county of Denver and the context of that. And so that's just not saying anything of substance, just an observation for you. But I want to talk about kind of amending and terminating conservation easements and the national standards for those a little bit. And I'm doing it without really being a comment in particular about this conservation easement. For context about my comments is that I was on the committee that drafted the national standards that were approved by, these are industry standards, not governmental standards, but they're recognized by a lot of governmental entities, that the Land Trust Alliance, the umbrella organizations for land trusts in the United States, adopted standards and created an accreditation commission in 2006 that I chaired for the first 9 years. So I was and have been intimately involved with those national standards. Conservation easements are intended to have some perpetual nature to them. They are done in the context of protecting land in perpetuity. So that's a comment about the expectation created. It's not a legal comment. It's a comment about the expectation created by putting in place conservation easements. And I guess I hadn't thought about it, but I would say to you that this task force is kind of created out of that expectation of, what was this conservation easement for and why was it done and should it be changed? So it is a serious business to change conservation, even just to change conservation easements. Amending conservation easements is scrutinized by the IRS. The industry standards provide that you don't do that except very carefully with a neutral impact on the conservation values, and you don't give private benefit, meaning you don't give value back to the donor of the conservation easement. A basic requirement of 501c3s is that you're doing this for charitable purposes and not for any members of your organization, and you don't give what is given to you as a charitable gift, you don't give back. And that's a fundamental kind of concept of a 501c3 under the Internal Revenue Code. So conservation easement amendments are taken very seriously. Having said that, I've amended a number of conservation easements for a variety of circumstances, not routinely, but a reasonably substantial number where occasion and circumstances required it. Sometimes as simple as fixing a legal description, but sometimes adding land, but sometimes fixing some things that just weren't working on the ground, and we did it very carefully. Terminations are a step up in seriousness. So the Internal Revenue Code doesn't set the standards for conservation easement under Colorado law, but it does set the standard for conservation easements if you want a federal charitable deduction. And there, the Internal Revenue Code provides that you really shouldn't terminate conservation easement except with a judicial proceeding where the conservation values of the property are no longer capable of being served. The industry standards provide that terminations should only occur in rare instances and with that kind of judicial action. And in 2019, the Colorado law was revised, and I know that some legal analysis was given regarding the Clayton Trust Conservation Easement and how it complied with Colorado law. And I'm not making a legal comment to you about that letter or what's right or wrong about that issue, but the change in Colorado law in 2019 also says this is a serious business to terminate a conservation easement. Excuse me for the water break. So those are the those are the general comments I wanted to make about conservation easements and what they are, and give you a little sense of how the community of private land conservation views them. And I think at this point I would just be glad to answer. I'm gonna step aside for 10 seconds, Dr. Ross, while I get my other bottle of water so that I get through this, and I will be back, and then I'd be glad to take any questions from anybody.